Good evening and welcome to the September 4th, 2025 Oregon Public Defense Commission Work Group. I'm Jennifer Nash, the chair of the commission, and we're here to potentially discuss a number of items that are on our agenda. We publicly noticed three main topics of discussion. One was discussions regarding expense policies, travel time, etc. The second one is the criminal attorney performance standards. And then the last one is key performance metrics. And we are going to table the discussion regarding the attorney performance standards because Mr. Arndt is not available due to a family situation to present on that. And frankly, we agreed, or I suggested that we publicly notice all of these, but I knew we were not going to get to all of them. So by moving that to our next work group, I don't think we are selling ourselves short because we weren't going to get to all these topics anyway. And the main topic of discussion, I think that will probably take up the most amount of time, is the revisions to the expense policies, specifically the travel time issue, which we need to discuss. So with that, there are a number of policy suggestions that the staff has presented to us in meeting materials, and for tonight, and also we've seen some of those previously. It looks to me from my review that other than the travel time, the suggested revisions for the pre-authorized expense policy and the routine expense policy are really more housekeeping matters to make language consistent and change some non-substantive things. I'm wondering, do other commissioners have questions or concerns about those or want to discuss those? Okay. Then I think we'll probably just bring those up for action item at our next meeting to approve those changes. And then regarding travel time. So that's the big thing we need to talk about. And of course, we know the backstory is that in 2023, I should say it differently, prior to 2023, the commission did not pay for travel time explicitly. I mean, there were people that were billing for travel time, but when they were traveling, but they weren't billing it actually enumerated as travel time. So when the commission changed that policy and billed for travel time as an explicit line item, our budget just blew up for travel expenses. And then this last legislative session for 25-27, the budget has not, the legislature cut travel time. So we have to figure out what we're going to do about that, what the cost will be, what the cost will be under different scenarios. We've had those already presented by Mr. Amador, and this time is to talk about that and also to ask staff questions about different scenarios that we may have for dealing with this. So I'll just open it up to the group to just generally start a discussion and also ask any questions that anyone has. No one has any question? I know someone has a question.
I'll go ahead.
Go ahead, Paul.
It seems to me that as part of our consideration of this issue, we should consider why aren't court appearances being made via Zoom rather than traveling. I understand you might have to travel to meet your client if they're in custody or if they don't have transportation. But when it comes to court hearings, it seems to me that we should be using video whenever possible to try and keep the expenses down for the state and to also expedite court proceedings, which is also an expense borne by the state in terms of judicial talent and personnel and the associated talent and personnel of people who are supporting the court system. The more we do by video, the more we save, the more courts save, the more the DAs save, etc.
So taking a step back and asking the broader question, do we have a breakdown or do we know the data regarding what the travel expenses that we incur are for? So kind of by category, who, so if we just said tomorrow, all right, nobody's getting any expenses for travel time, what would that mean? Where do we incur those expenses? Are they for lawyers? Are they for investigators? Are they for expert witnesses, et cetera? Do you have that data available?
That would be me. That would be Chair Nash. This is Ralph Hamilton from the commission. That would be me. Yes, I think I have a PowerPoint slide that we can talk about that shows that. I provided some of the information before, and we do have it broken down by attorneys, by investigators, by different paraprofessionals as well. We can break it down pretty succinctly, but we have some major groups. Are you wanting to see that, or I guess we're gonna look at that right now. How about I just start going through this and we'll ask questions from there if that works.
That would be great.
Okay. So if you remember from the last time, we wanted to go over a few explanations of terms so that we are all on the same page. And if I slip and throw an acronym in there, we'll understand what we're talking about. LAB is legislative adopted budget. Reduction is funding removed from the legislature. Travel time is time spent traveling or en route to a destination where work cannot be reasonably performed. Court mandated expense is hourly cost, interpreter, and other case costs that are determined to be routine. Reauthorized expense is investigator, mitigator, expert, psychologist, case manager, etc., including case-related expenses that are determined to be non-routine. FY24 are the expenditures paid through July 23 through June of 24. Fiscal year FY25 is for fiscal year 25, and those are for expenditures paid during July 1 of 2024 through June of 2025. Next slide more. Okay. When we talk about the 15.82%, we're talking about this. That's the overall rate our caseload is expected to grow this biennium based on the current forecast for the 2025-2027 biennium. This percentage amount is added to the expenditures for 23-25 to demonstrate the projected costs for 25-27. One of the proposals we had was the $50 per hour proposal. That was a proposal that providers would be paid at $50 per hour for travel time, regardless of their hourly service rate. We introduced another one based on the conversations from the last time, which was 75% of the hourly rate proposal. And that proposal was that attorneys would be paid 75% of their standard hourly billing rate. Half rate per hour proposal, that was a proposal that hourly providers would be paid at half of their hourly service rate for travel time. We made the statement that OPDC will continue to fund other travel expenses with no change to current policy for mileage, lodging, airfare, car rental, and meals. Next one more. This was just to review the action that was taken. What had occurred was that in the legislatively adopted budget, meaning funding was not included in our budget. Court mandated expenses was reduced $1.8 million, and pre-authorized expense was reduced $3.5 million. We made the assumption that travel time expenses are expected to continue, so we listed 23-25 expenditures as they came out towards the end of the biennium. Court mandated was $2.2 million. Pre-authorized expense was $3.6 million. With that, we said travel time expenditures, it projected increasing it by the 15.82% increase. Then you could expect 2.6 in court mandated expense and 4.2 million in pre-authorized expense if the commission took no action and just did nothing. Okay, more. Here's what we started breaking out. So what I did differently from this presentation to the last presentation is that I grouped expenditures that would be mainly you could expect in the court mandated area, and then subsequently I did the same thing for what you could expect in the pre-authorized expenditure category, which comes later. So for fiscal year 24, we had about with attorney travel time and some interpreters that came out through court mandated expense. FY 24, we had 4,500 hours and $782,954 paid out. For fiscal year 25, for that same group, we had 6,900 hours billed, and we paid out $1.18 million in expenditures, for the grand total of 11,521 hours and $1.9 million paid out.
Okay, but it looks like we have a question, so let's
Okay,
go ahead.
With this breakdown of travel time and attorney travel time, are these two the two attorney lines, are they to mark different types of attorney travel? Is it hourly attorney? What? And you may have answered this and I just didn't catch it, but
Commissioner, to answer that, it was because I wanted the data to remain true. So one of the lines came from the pre-authorized expense display from the last time, and I just brought it up. Because I didn't want to convolute any data by having numbers missed in case people looked at the last presentation and compared it to this presentation. So I was just simply moving lines from one spreadsheet to another one.
From one budget bucket to another.
Yes.
Okay.
and so is that pre-authorized attorney travel, is that strictly hourly attorney travel, or is that also travel for the other types of attorneys?
So court mandated expense would be for hourly attorneys. In the pre-authorized expense, you'll have some attorney travel in pre-authorized expense. There's a smidgen of it that you'll see in the next slides. And that's because in some pre-authorized expenses, there is a request for other attorney help that's not that's billed at the attorney hourly rate. So if somebody asks for some assistance, some research or something else that does that, you would see it show up in pre-authorized expense.
So I guess, and this is again my newness, but so like for consortium attorneys, that's not necessarily going to be in this chart.
No, sir, that would be in the contracts.
Okay.
Yeah, they don't, so consortia attorneys don't get paid travel time. It's necessarily, but if I needed some help from a specialty lawyer on a case and I got authorization for the agency to pay that lawyer hourly, and that lawyer needed to go visit my client, that's what this is. That's what that smaller line number is. That 221 hours, that's the bucket that comes from.
I super appreciate that. That's super helpful and clarifying. Can just for my own 10,000 foot view of everything, what portion of the total cases do hourly attorneys cover? So I'm just wondering, what portion of the overall budget we're looking at here in terms of case carrying capacity.
In our Commissioner, in our forecast, we estimated it was about 5% or so, but it's more like I think it's a little bit higher than that, but I think we started out about, when we did our forecast, we did about 5.6% of the cases in the projected forecast would go to the hourlies.
And I will say there is an effort, and this relates to our overall discussion. There is an effort to roll some of those cases back into contracts and to roll some of those cases into the state trial division. When we've had this large unrepresented list and trying to get as many lawyers as possible to take those cases, there's been just a huge outreach to try to find any lawyers at all. And I think now, I mean, it's still happening, but I think now the focus is shifting slightly to trying to get the contract entities or state trial division to start taking more of those cases, which will have the effect of reducing the travel budget, because those lawyers don't get paid travel time. So that's one of my questions, is if we roll up, I don't know, 2% or something, you know, what, can we achieve some of these savings through sort of natural shifts that we're making in caseload distribution instead of cutting travel time? Or if we do that, how much of it could we recoup from natural just shifts in policy?
My guess, Chair Nash, is that what you're saying, if we effectively move cases from the hourly buckets in the future, hourly buckets to the contracted areas, it will have an effect on travel time. And that would be in the latter part of the biennium, because most of what we're going to be seeing now are the cases that are being assigned now or have been assigned. That it's still that matriculation of that information going through. So if we start shifting now to try and get more cases off the hourly to the contracts, again, in probably the second year of the biennium, we should see some savings start to matriculate throughout this.
Do we have a sense since July 1st of 2025 whether or not there's been a decline in the percentage of cases that are taken hourly because of the rates being cut?
I don't.
Or any other reason? Yeah.
Chair, I do not have that in our expenditures. It's really conflated because of the amount of money that was paid out in July. The effect of people really, when we change bienniums, people tend to turn in a whole bunch of bills, so our expenses go up for the first month or so. So we really can't say. We can ask the data team to try and pull that information for us. Again, we're still working on a pathway to use OJD data and our own billing data to actually see where these hourly cases are going and how many are coming at us at a time. It's really too soon to say something constructive about that.
Okay. That's helpful. Thank you. Do other commissioners have questions or comments so far? Okay.
Excuse me, I do have a question. So the way I understand it, these hours are only for hourly appointed attorneys. And is there a limitation on them? Like, we don't pay you for travel time we only pay you travel if you're traveling outside of your county, or is there a limitation on that?
Yeah, I actually looked at the contract because we have that in the materials. I saw that when I was reviewing the expenses. It is only for out of county.
All
So
right, thank
if
you.
you're traveling in county, you don't get paid.
That would be the policy, yes.
Oh, that's much better. Thanks, Ralph.
Right, I had to switch mics, sorry. Zoom in Teams.
Much better, thanks.
Of course.
Okay.
Okay, so we left off with the grand total. Then the 15.82% again is the attempt to project out if expenditures stayed the same, we would multiply the hour, increase the hours, increase the costs. And so the projected amount would be $2.2 million to be paid out. If we went with the $50 per hour proposal, again, that would be $600,000. Half the rate per hour proposal is $1.1 million. And for the attorneys only, and I put this on there, this is new, and this is just for the attorney hours only. And I put that in there because there's some interpreter hours in here. If we did increase the attorney only hours by 15.82%, and then took 75% of that rate, you could expect to see a projected cost of $1.7 million. So, and it can't reiterate enough that the court mandated expense is one that the money we spend from this bucket just reduces the amount of money we have to pay for hourly cases. So commensurate with what Chair Nash said, if we lower the amount of hourly cases that are going out, then this number will go down, and the other numbers will go on as the number of hours will go down as well. So we could achieve savings there if we're effective with our policy decisions and carrying forth that. And I just got a correction on attorney travel. It's for out of county 50 miles or more.
Both conditions has to be out of county and it has to be 50 miles or more.
Yes, sir.
Thank you.
Amy's saying no.
So it's or.
I'm going to look because we have it right in front of us. So I'm just going to pull up the policy.
It's or.
It's or, okay.
Yeah, which would make sense, right? If you're in Eastern Oregon, you don't have to drive 200 miles before you get paid for travel, right?
Yeah.
Okay, next slide, Maura. So just to be transparent, I wanted to give you what the pre-authorized expense budget projections are and what it looks like. We break down the pre-authorized expense budget in 3 areas: mileage, meals, and lodging, expert services, and out-of-pocket expense. And we'll go into these. The next slides will detail what's in these in a minute. So just so you'll see what's in there. But projection-wise, with the we're looking at 4 million in mileage, 95 million in expert services, and out-of-pocket expenses, 600,000. And those are the ones, and those are inflated 15% to account for the growth. So our projected totals would be $100 million. I have here in blue projected service hours, and that again in the next slide I'll detail that more. That's because right there, that's the cost of investigators, mitigators, and case managers, because by policy, their hours are broken out by us to adhere to the policy of tracking travel time, but really they're in the service hours. So if an investigator is 25 hours, that's all together in there. So we're assuming I have to put that 1.3 back into the total when I'm looking at availability, because we're going to pay that anyway. So we're looking at $101.3 million of expenditures projected. Our pre-authorized budget is $101.4 million. We have 1 million in other funds, meaning if we have enough qualified expenditures for 4E, then we can change that money, pull some federal money down as other funds, and increase our budget to 102 million. That would leave 1.067181 in unobligated funds remaining. That's important because that's all the money we have left in this budget for anything else that happens, without any decisions on travel time or anything else at this point. So I'll pause for questions.
Meaning that if we did nothing, we're going to be short $1,067,181.
No, this does not include paying for travel time.
Right. Sorry. No, yes, we're short. Okay. Thank you. We're short no matter what, is what you're saying. Go ahead, Tom.
Mr. Amador, I'm interested to see that the price tag for expert services is so high. And thinking ahead in the long term, is there any chance we could bring certain experts in-house in the trial division? I mean, are we losing an opportunity for cost savings by not employing certain categories of experts directly? Or is it just such a diverse range of experts that we could never expect to hire a full-time expert to make it cheaper?
Or have contract for
contracts, right?
forensic experts.
So just to follow up on Commissioner Nash, I'm sorry, Chair Nash's comment, Commissioner Laddier, when we do set up a trial office, state trial office, we do include investigators, some case managers, paralegals, and some discovery clerks which are part of the expert services in there where we can. So those are part of the build out of the trial division office. But as far as psych and everything else, and Mark, can you go to the next slide? Oh, sorry. Well, we'll get to the further answer your question in just a minute, sir. But this is the 4,100. This is the pre-authorized for miles, meals, and lodging. We're projecting $4 million direct bill for lodging, meals, overnights, and no overnights. Mileage is 3.1 million, and other travel reimbursements $585,000. This is what we're projecting just to spend in this next biennium. Go ahead, Mark. Here's the expert services, sir. So we have attorney fees. These are the expert attorneys that if you need assistance or something like that, that's where these costs would come in if you need help in your case. Case management services are case managers as they're requested. Interpreter fees are what they are. Investigation is $25 million is what we're projecting to spend, and that's with the increase. This investigation fee is highlighted in a different color because this is for THIP. We were given buckets of money for THIP and court mandated expense and in pre-authorized expense, and all the expenses go there. So we don't consider those as part of the bucket when we're talking about things. Commissioner Nab?
I was wondering how, and again, apologies for the cursory question, but how these fees are shared amongst the different models. So I'm assuming these investigator fees aren't only hourly attorneys, they also include the consortium attorneys. But
Yes.
But the nonprofit providers have investigators as part of their line. Is this included in that or not?
No, sir. Investigation does not get charged from the not-for-profits if they have an investigator, unless the caseload is such that they cannot do that. They will make special cases to where if they need additional investigative help, if they're totally overwhelmed with their caseloads and everything else they need it, then there will be times when they'll have a pre-authorized expense request, and then we will approve it at that point.
Is there any breakdown of how these expenses are being shared throughout the system, consortium, hourly, nonprofit? Or is there any way of knowing that? I'm just curious.
I'm not going to say we can't do that, but that would be very detailed because we track it on the case numbers. So, and then the payments that way. So that would be pretty hard for us to do given our current systems. I would assume that with the financial case management system, when that gets up and running, that will be able to detail these things very, very well at that point. I'm not going to say data can't do that, but I'm not going to say that they can because that's a big lift.
Yeah.
So I will say, fees for like psychiatric fees, polygraph examinations, transcription, translation, all that, those are incurred by all entities. So the only thing that the nonprofit public defenders have that's in-house are investigators and case managers sometimes. The rest of this, and they have paralegals. So the rest of this is all for hourly or consortia.
That's correct, ma'am. So next slide, Maura. What was this one? So this was just a breakdown of the service hours that were paid. Because if you remember on the previous slide, there was 1.3 of service hours that were brought into this. So this is the travel time for investigators, mitigators, and case managers. That would be taken in consideration. That we wrapped into the pre-authorized expense budget. And again, you'll see there's court mandated and pre-authorized expense categories. Again, I was trying to get we'll be making sure all this information gets put into pre-authorized expense as we're coding it, so it doesn't show up this way next time. But this is to get a correct bucketing of information at that time. That's just to demonstrate what we were talking about. Go ahead, Maura. This is our last area of the pre-authorized expense budget, which is out-of-pocket expenses for copies, court reimbursements, out-of-pocket expenses for attorneys, and just things that an attorney has to pay for that we pay them back for. Make sure that they're made whole. Go ahead, Maura. I put this slide in there just so you can see what the THIP stuff was. So this is the money for THIP money for court mandated expense for travel time. This is all court mandated, goes into a special allocation for them, and then PAE does the same thing. So it's paid as service time and for investigators. And so that's just to demonstrate what we're doing there. So just so you know that it's a separate bucket of money, not counted with everything else.
And the THIP budget was put together at the full travel rate by the legislature.
At the rates that they're getting now, yes, ma'am.
Okay,
Because, I mean, and we can do this because DIP's a closed program now, so all the expenses are gonna be what they are. There won't be any fluctuations. Go ahead, Maura. So this is the problem that still needs to be solved. This is so we talk about court mandated expense. On that level, we pay for it or we don't, and that reduces the court mandated expense bucket. If we reduce the amount of hourlies, then we have enough money to cover that if that's what the commission chooses to do. The mitigators, investigators, and case managers, that's part of their service time. So we've solved that problem, but that reduces the amount of money available in the PAE bucket. But what's is still out there is the stuff for interpreters, other experts, psychiatrists and such, that's just still out there. And that equals, when you inflate it, to $2.4 million of, this is what's still out there to be decided on how we're going to pay this. You have the $50 per hour proposal, which takes you to $719. You have the half rate per hour proposal, which is $1.2 million. So this is the really unsolved part of this right now. Leaving court mandated aside and its own side, and on the PAE side, this is what's left. So if you take that, you can consider that you have $1 million left over that's unobligated, but you have potential of $2.4 million of problem here. Go ahead, Maura. Oh, Commissioner Nab.
And I know I brought this up last time, but it really, with a budget as, you know, incredibly large as this, it seems like there might be ways to limit or monitor more closely the use of these expert services that would reduce that budget. And I know I've never practiced criminal defense in Oregon, but you know, just on its face, that budget of 100 million for experts is incredibly large. And you know, in my time practicing in New York, my time practicing in Washington, you know, this certainly, I understand from talking to practitioners here, there's much more of utilization of experts here, but it really seems to me like there's got to be some answer that addresses substantively rather than addressing you know, flat fees and rates to come up with that difference. And not saying that there shouldn't also be a change in the travel time rates, but just something that that perhaps changes the calculus on how and when and why and experts are being used. And so, you know, it seems like just kind of with an overall budget that is that large, that you really could find that number within some substantive changes to how these are being approved.
and maybe I think that's certainly a big part of the discussion, and I mean, a big part of the solution. I think that's right. And I'm wondering, I mean, Ms. Shaber's been around forever, and maybe she can talk and put her on a spot a little bit. This isn't exactly her area necessarily, but she knows everything. You know, about how the process has changed and evolved and how it is now. So it used to be, I was telling Ken this the other day, it used to be that a lawyer would ask for a pre-authorized expense. I need this expert for whatever. The line person would say, no, you don't get that. So then we'd pick up the phone and we'd call general counsel and we'd say, hey, listen, I really need this expert, and here are all the reasons why I need this expert. And he'd say, well, okay, but you know, I'm only going to let you do this, or I'm only going to let you do that, but I understand, and that's fine. And then it would get approved. That was how long time ago, you know, there's no policy. There's just whatever general counsel thought, that's how it happened. And then it kind of became a little more ministerial. He wasn't, general counsel wasn't making those decisions. It was staff that was making those decisions. And I don't really have a good sense about whether or not it went up or down. But now what we have is we have a kind of a tighter structure that's a little bit different, and it's relatively new, and that structure may address some of these issues. So maybe Ms. Shaver can talk about that a little bit.
You're correct. I have been around forever, but unfortunately I don't know it all. That is absolutely the way that it used to work. And general counsel was certainly more involved, and I'm hearkening back to Paul Levy days.
Yeah.
And then, the contract analysts did PAEs for a long time. And during that time, we kind of worked with general counsel to develop a set of criteria, things that we looked for in each request in order to be able to evaluate them. And that's not to say that sometimes things didn't rise again to general counsel level. They often did. But that set of criteria has since been incorporated in the PAE team. Certainly when I was PAE manager, we had multiple discussions. We continue to have those discussions about the set of criteria, is this request for counseling for a client that's in custody, something that the agency should be paying for. And direct client services, as you all well know, is not something like that we fund. But we, while it's not well, it is in some areas, I suppose, actually documented. Here's what you should be looking for in each type of request. It isn't in all requests. Does that answer your question?
Well, a little bit. Is my understanding is there's now a committee too that kind
There
of
is.
about
That's
if there's an issue regarding
right.
rejection or So can you talk?
Absolutely. It's the reconsideration panel. So if one of the program analysts in PAE denies a request, let's just say, for example, it's because there isn't enough information for us to be able to evaluate it. We've emailed the attorney, we deny the request. They come back with the information that now allows us to be able to review the request and make a determination on it. If we would then again deny the request, then it goes to the reconsideration panel, and we take the original request along with the original denial, along with the information, the new information, to the reconsideration panel, and it's reviewed by the panel.
I wonder, to what Commissioner Nab was talking about, do you have a sense if the criteria was modified, if we would be able to recoup savings, or would, I guess an easier way to put it is there waste, which is a terrible way to put it, but is there any fat that can be trimmed, or is the agency already really pretty strict about what gets funded and what doesn't? Yeah, that's a really tough question.
Well, it is tough because, right now what we're talking about is travel time. And you saw on one of Ralph's slides what we're paying for travel for psychs. We have providers from Portland who travel to, Jackson County to do psych evals because they can't get anyone closer to them. The people that are, in the surrounding counties, even Lane, Marion, they're booked. So, and plus, everyone here knows how that goes. You find somebody who tells you yes one time, and as an attorney, you go back to that same person in the same way that the agency does, right? Is there fat that can be trimmed? And the answer to that question is yes, there is. Have we done a lot of that trimming in the last year? Yes, we have.
Yeah, that's really what I'm wondering. Is there fat left to be trimmed? And my sense is not a lot at this point, right? Yeah. So here's the kind of the difficulty, of course, that we all know. If you cut, so I received a letter. I saw it. Unfortunately, I didn't check my commission email last week. I just looked at it today. And there was a letter from some forensic psychologists, and I'm going to forward it to have Mara forward it to the rest of us. Basically said what you're saying, and that is, we travel all over the state because there's no one else to do it. And there aren't very many of us, the letter said. There's like 141 forensic psychologists in the state, and most of them work for the Oregon State Hospital. And so there's just a handful that can do defense work. And, if they're traveling, it's not because they, want to make a bunch of money on travel time. It's because there aren't any forensic evaluators in Medford. So then we say, okay, well, we're not, and they said, we're already underpaid, and we can't sustain, we can't justify traveling, to these places if we're not paid to do it, because we're already doing this at a reduced rate, which we all know that's what hourly lawyers are doing too. So my worry is, for both attorneys and experts, we don't want to create a disincentive to do the work that needs to be done on cases by making it so that people can't make a living doing the work that needs to be done on cases. And so I don't know how we solve that problem. And I have a pretty significant concern about the unintended consequences of, or maybe the intended, who knows, but the unknown consequences at this point about what happens if we say, okay, well, we're only going to pay you 75% and we're not going to pay you at all, or we're only going to pay you $50 an hour. What does that look like? I don't think it looks good. I think it's a big problem, but we also don't have the money. So I don't know. I don't know other people. What are other people's ideas or thoughts? Commissioner Nahab.
Yeah, so I mean, I guess, and I certainly don't want to characterize any of it as fat. I know everyone is trying to make this work as as lean as possible. But I guess my question is, within the practice, and I do think that it is a little bit of an anomaly that within the practice in Oregon, there is that much utilization of experts and psychologists. And so, certainly we don't want low-income folks to be disadvantaged because they have public counsel. But I think that the point I'm making is that, is there real scrutiny going to the utilization on when these are being utilized, and has that been revisited for a while? Because in my professional experience, that is an incredibly high utilization for this type of expert service. And so I guess this is more a question for the agency as a whole, but has there been any real scrutiny of like, is this utilization in all of these cases necessary to effective representation, or can we change the substance of when we find this type of utilization necessary? So that was just, I certainly, I want to make sure that I'm clear that I know that everybody is working really hard to make this work as effectively as possible. But just as an outsider looking in, wondering is that utilization, is that very high rate of utilization something that is necessary to effective representation? And that's just a question that I don't have an answer to. I just wanted to reframe.
Ralph, I'm wondering, do you know, and I don't need exact numbers, but just a sense, if you know whether or not most of the requests for forensic evaluations are aid and assist, are they competency, or are they like GEI or mitigation related?
I just ran, Commissioner Ness, I just ran those numbers for another project I was working on, so I'd have to try and pull that up. I believe a lot of it changed, for aid and assist went up a lot once we created the short forms. It went up a lot. I mean, everything was getting aid and assist at that time because we created an opportunity for them to just go ahead and do the aid and assist and do the paperwork afterwards because we didn't want to become a barrier. Your Commissioner Nav is asking a budget person if there's ways to trim to save costs and everything else. This is something that I've been struggling with the entire couple of years that I've been here. Is like, wow, this is just huge. And the threshold, our threshold that we work with, is reasonable and necessary, and that's huge. Because who am I to say what's reasonable, what's necessary? And the attorney is the best person to do that. On the other hand, I'm doing a lot of reading from other states, Washington, Massachusetts, North Carolina, other places, trying to figure out what they're doing there. We eclipse them all. Even the federal panel has language that says, we want you to negotiate down with these rates. We want you to do things. Idaho pays travel time as window time, and it's $50 an hour. That's what they pay for everybody. So, and then a lot of these places don't even list their experts because you have to make a formal request for an expert and make a case for it. Ours is almost automatic on a lot of things. So when you ask, have we done detailed analysis on whether it's overage, I'm going to be honest with you and say we have not. We've been reacting to a crisis. The last couple of years before this commission and before the commission before that, we were under the auspices of leadership that said, pay for everything. Everything's reasonable and necessary. You must pay for everything and don't say no to anything. For a year and a half, that's what we were operating as. That was my first year here. And so it was like boom, boom. And so we create this expectation of what it is. Now we're like, oh, this has gotten huge. Now we got to look at how do we dial it down? Do we dial it down by saying, putting, thresholds on what each case type is? I mean, there's certain things that we can do to say, here's what for this type of offense, you can have these services here based on what a normal thing is, and anything more than that, you have to say why you need it and give an explanation of why you need it. We could limit to just Oregon providers. We have a lot of, the providers that are out of state are hugely expensive because none of them want to work at the rates we have. We have to negotiate down the rates, and then they want travel time and then time to talk in the courts. I forget, talk in the courts to testify. All that adds up to just huge amounts. The travel time is large now for attorneys because, again, responding to a crisis, we can probably do better assigning cases. We shouldn't be assigning Portland attorneys to Coos Bay or to Medford if we don't need to. And as we put state folks down there, we can maybe mitigate some of that, because if you have a murder case a thick murder case at $200 an hour, and it's in Medford and you're Portland, well, we're paying you, 10 hours of travel every time you go down there, plus the $200 an hour. So a lot of this adds up when you don't think about it, but we're responding to the crisis. As we start managing the crisis and start getting better at, because this is something we'll have to do when we institute our financial case management system, is start setting parameters on what each, drop down menus of what each case can do. If you have a misdemeanor, here's what's available to you. And then what it is, and trying actually, I wouldn't go as far as say like the federal panel has a budget. You have this much money to spend, including the attorney time. And if you go over that, you have to say why you're going over it. And we can tell you, no, you can't. That's like a world of difference from the way we operate now. So I think in time we can get there, but I don't know how quickly we can get there. If that helps. So I'll be quiet now because Commissioner Harris and Commissioner Lipscomb.
Yeah, Rob, go ahead. That's really helpful, Rob. Thank you.
Yeah, it seems like we've been talking about, two separate, related but separate things. One is, should we pay the travel time for attorneys? And the second, if we have a hole in the budget, how are we going to deal with that? both are important. My thinking is, if our primary concern right now is the unrepresented crisis and getting people lawyers, then the risk that we have a worsening crisis because we are limiting travel time is not worth the risk. And we do it. Now, I would still propose, I think I had mentioned earlier, a 75% of the rate. And there's a couple of reasons for that. Number one is, if you're in your office, you're probably actually billable hours, because these are hourly people we're talking about, billable hours, and they're probably doing 6 or 7 hours a day billing if they're there for, anywhere from 8 to 9.5 hours. So 75% rate is reasonable for a 2-hour drive. It's an hour and a half billing, right? So they would get something similar. The other thing is, it does incentivize them, lawyers, providers, when they are able to pick up the phone and make a phone call or do remote or do Zoom, rather than incentivizing them to getting in their car and driving 4 hours. So I think it's a fair number. I think it's the right number to incentivize the right behaviors and still do an excellent job. And I think as far as the budget hole goes, I think, what was it, Ralph? But 1.7 if we went to 75%, and we had about a million plus, that still leaves us $750,000 short in a budget this size. And so I just think we should do that, or something along that line. And secondly, as far as paying for it, well, I hate to say we have, 21 months to deal with it. We do, but also we consider what Commissioner Knab said about reviewing the qualifications or whatever we want to do on some other areas of budgeting that we can maybe be a little more efficient on. And also, we're doing key performance measures. Maybe one of the key performance measures we include is efficient and appropriate use of experts. And that doesn't mean getting an expert on every case, but when is it appropriate? So I think there's things we can do over the balance of this contract. I think that if we did not compensate a fair amount to lawyers who have taken out of county cases, we would be going backwards on the unrepresented crisis. And I think that risk, and it may not materialize. I suspect it will to some extent. It's not going to double the number, but it's going to make it worse probably. Also, it's just sort of the fair thing to do, in my opinion. So I say we do it something along that lines, and review the budget process for the balance of the PAEs and CME expense items. Thanks.
Thank you. Paul?
Yeah, I've been sitting here thinking about all this and ways, really what this represents, and what, if I were a skeptical legislature and I were looking at the same information we're being provided with here today, I'd want to know, my goodness, what's the likelihood of these cases that we're paying so much money on for upfront costs? What's the likelihood of them actually going to trial? What percentage of these cases where we are providing these extraordinary expenses really go to trial, and what doesn't? And I know that's not the only way to look at this, but I think that's a way that we need to be aware that our constituents are probably going to be looking at it this way. And I don't know the answers to those. I don't know when these requirements are being requested, how early or late in the game. We all know that regardless of whether it's a misdemeanor or a low-level felony, that those cases rarely go to trial. And it's only in really extraordinary cases that criminal cases actually do go to trial. And I think we need to be aware of what our answers would be if somebody asked these hard questions about how much are you paying for travel time and professional time when you're never going to use, you're likely never going to use any of that in representing this individual who can't afford to pay for his or her own defense.
Thank you. That's very interesting and insightful, and it would be good data to have. I think that's very good data to have for lots of reasons, actually. So you said something in passing, or Amy did, like one of you, about the short form versus long form, and I forgot about that. So it's important, I think, for other people too, because I think that's a huge thing that we could fix very easily. It would have repercussions on staff, though. So let me give a backstory. Used to be like for every expert, every investigator, everything, you had to put in a request. You'd have to justify why you needed the request. It would take some time to process. If it was an emergency, you could say it's an emergency and you would get it back faster, then you get back an authorization. For investigators, we switched, and there was a short form. By we, I mean, I wasn't part of that, but the commission back in the day switched, and automatically you got a certain number of hours that were authorized because, you need an investigator, you're going to get them quickly. That also changed, though, for forensic evaluations. So forensic evaluations, because we're having staff issues with how long it was taking, and there were also just the law changed regarding the requirements for getting a forensic evaluation and the timing. And there was not, we all know this, during the pandemic, an explosion of mental health issues. And so we went from a long form where you have to do that, justify everything, to that automatic. You get it. You ask for it, you get it. You get a certain number of hours, it's done immediately. So one of the things we could do is we could stop the short form process for the aid and assist evaluations and go back to a long form and have people, or forensic evaluations, and have people justify on a more robust purpose or more robust basis why they needed that evaluation. It would slow down the number of how long it took to get that authorization. It would probably not, I mean, we'd have to, I don't know how many it would capture, but certainly it would capture some that probably shouldn't have authorizations or don't need evaluations that are getting them. So that's a thought. We could consider that as a substantive procedural change rather than the money part. Also, I heard changing to the default to be Oregon providers only. And if you want someone who's not Oregon, you have to have a really good reason and justify it. And it has to have some extraordinary reason. We could make that policy change. I also heard being more careful and scrutinizing how cases are getting assigned to hourly and out of county attorneys, to try to assign those by region to the extent possible to limit the travel time. And I also heard limiting the number of hours upfront for all investigators, experts, everybody. And if you need more than that, then you have to come back and justify that. And then I heard suggestion to reduce the travel rate to 75% rather than 100% for experts. So those are the five things that I heard talked about as substantive ideas. We're not making any decisions here, but those are things that I think that we should talk about in future work groups, and things that we should give some direction to staff about what we want in policy, if we want any of those as policy changes, and then implement them as policy changes. So we have another work group that's scheduled. We're going to start doing a work group before the commission meetings and then start the commission meeting an hour later. So we kind of have two opportunities for work groups. So if we can't talk about it the next time, we'll talk about it in our October work group. But because Rob's right, we have 20 months by then to solve this problem. Not to solve the problem, but till the end of the biennium, we have to solve it quicker than that. But I think I heard some really good ideas. And if there are more good ideas, and keeping data, of course, I think is an excellent idea as well, to try to figure out if there's some correlation. I think that's super important, and we need that information as well, between the amount of expert services utilized and the outcomes. That can be difficult, but it certainly is something to because correlation doesn't equal causation, but it's certainly important data, I think, to have. So I want to wrap that up and move on to the KPM discussion, but is there anybody who wants to add anything to that, to this before we move on to the KPMs? Okay, thanks. That was really good work. Thank you to the staff and thank you to all the commissioners for that discussion. It's very helpful. Okay, let's move on to the key performance metric discussion.
Good evening, everyone. Thank you, Chair Nash. I'm Kim Freeman, for those of you that I have not met. So I am the Compliance, Audit, and Performance Operations Manager, also known as CAP. I'm here tonight to just, one, talk about our current key performance measures, also known as KPMs. So for Commissioner Nab, you'll get really used to a lot of acronyms here, but we try to spell them out for you. So bear with us, but I think we're usually pretty good at that. And then to talk about where we are today and where we want to go with looking at our existing key performance measures, either keeping the ones we have, changing them, eliminating them. There is a process that we have to work through as a commission and as staff, and then present to the legislature for final approval. For some context, the agency has 5 key performance measures, which everyone has a memo tonight, and I apologize, I did not do a PowerPoint presentation for you. But at the September Commission meeting, you will have a full summary of our key performance measures for 2025, all the survey results. You'll have a lot of more in-depth on the 5 key performance measures. But the reason our agency does key performance measures, it's a requirement by the legislature. And it's part of our annual performance progress report, the APPR. So it's our agency expression of performance measures against legislative approved KPMs. And this report is required each year, and it has to be submitted to the legislator by October 1st every year. So our current 5 KPMs are appellate case processing. So this is the median number of days to file an opening brief. Our customer service survey, and we conduct annually a customer service survey that goes out to all of our providers, contractors, investigators, everyone that's in what we call our constant contact database. So that right now, all of that was about, well, if we used everyone, it's 2,200, but we only sent the survey to 1,432 participants. And we are looking for good and excellent. That is our overall measure on that one. As you know, the commission does a survey of the commission members conducted by Vice Chair Mandenberg on best practices of boards and commission. We have one for our trial level division. That's our contract attorneys, that they complete continuing learning education 12 hours per year. That one has always caused a little bit of heartburn for our contract attorneys. One, because you have 3 years with the bar to complete your 45 hours of continuing learning education. Our contract for our contract providers says 12 hours within 2 years, and then the KPM is 12 hours in 1 year. So every year when I do this survey, it's very confusing to our contract attorneys, and we get lots and lots of questions. So I appreciate everyone's grace with us and just answering if the answer was yes or no, if you completed your 12 hours. And then our last one is our Parent-Child Representation Program, PCRP, and it's the percentage of attorneys who spend approximately a third of their time meeting with their court-appointed clients. These 5 current KPMs have been in place since 2016. And that's as far as I could go back and find these KPMs. And we post them on our website and then on the legislative page as well. Also, in May of this year, we have been directed by the Legislative Fiscal Office to submit a memo on what we want to do with KPMs. So I have included that in your information tonight as well. And these are suggestions just from internal staff working with our Deputy Director, Emma Shea Perfecto, on just thinking about where we would want to look at potential KPMs, which ones we want to change, and then also working with the commission on your thoughts, because I've been with the agency 2 years and I've heard lots of comments on we need to really look at KPMs, we need to change them, update them, create new ones. There was even conversations tonight about that. And then we do have a new direction from legislature for a new proposed KPM, and we do need to report back in the 2026 session. So the new proposed measure is for the percentage of financially eligible defendants or persons receiving a public defender with a target of 100%. So what that means is that no one would like to see anyone on the unrepresented list, right? That everyone has an attorney for anyone who is financially eligible to have public representation. So that goal is 100%. So that is a new one for us, which we'll be working on, what that measure is, and go forward with that one. I just want to pause there to see if there's any questions.
I saw that, but can you read that last one again? The new proposal.
Sure. So the new proposed measurement is for the percentage of financially eligible defendants / persons receiving a public defender with a target of 100%. So that it's 100%, we need to meet that no one is on the unrepresented list.
In what timeline?
Well, Chair Nash, that was not a given. And when I read this in a very different way. So when I read this potential KPM, I look at that as when people come in to, when they're charged with a crime and they come into the verification specialist whom works in the court or at the judicial department, and they fill out all the required documents to see if they're financially eligible for a public defender. I read that means everyone that's coming in, if they're eligible, they automatically receive a public defender. In talking with Lisa Taylor, our government relations manager, she is under the understanding that this one means no one is on the unrepresented list. So I do believe we need to get some clarity around specifically what this particular KPM is, because I read it very differently than that. And a KPM, Commissioner Lipscomb, is a key performance measure. So these are measures that
Data point.
These are measures that we have had in place in the agency since 2016 that have been approved by the legislature as a measure of performance of this agency. Again, these are old, and a lot of them need to be totally redone, revised, and potentially some new ones.
So yeah, the problem with that last KPM is that, well, and the expert on this is Ken, of course, who has his, advanced degree in this area, but it doesn't tell you the data that you're really attempting to capture will not be captured by the KPM. If what you're really trying to figure out is whether or not there's anyone on the unrepresented list, that KPM isn't going to capture it. And also, if you're trying to determine, that's why I had you read it back to me, because I wasn't sure what it was asking either. If you're trying to determine if 100% of people coming in are eligible, we also don't, who are eligible, get a lawyer. We don't have control over that. That is not we can't do anything about that. That's a function of the judicial department in part. So why are we measuring something that we can't control? So I think it does make sense to find out what it is that they want and then craft our own question to answer that, to provide that data.
Totally agree, Chair Nash. Thank you.
Yeah. Yeah, well, I think all of these are not written well, frankly, many of them are. I mean, the only one I think that is written very clearly that we can measure is the appellate opening brief, because that is, okay, from start to finish, you have a number and there it is. And just just for those of you who are curious, that KPM, it's been almost the exact same number the whole time. It has never changed, or within just a little bit of a deviation, which I think is very interesting, because I don't know what they were trying to measure, or what they were trying to accomplish. Like if they were trying to prove what needs to be shortened or it needs to be lengthened or whatever, the number of days, but the number of days from filing to opening brief has remained almost static for the entire time that KPM has been in place. I found that to be very interesting over the years. Then the rest of them are all very squishy and difficult to measure, because also, what does customer service really mean? Yeah, anyway.
Right. So when we look at KPMs going forward, we are required to have a customer service survey. So we will always have a survey. Now, can we change the questions we ask? Sure, right? We can. We would just start over in our measurement. For just a little history around that, this is our second year. So I've been at the agency a little over 2 years, and the KPMs have fallen into my team. And last year we did a customer service survey, and we did one this year. And then 3 years prior to that, the agency had not done a customer service survey. The survey last year went out in the height of when the agency was severely behind in paying our providers and paying invoices. And so, as you can imagine, the comments and the results were not very good, right? And we knew that, and it's good for the agency to have good feedback and negative feedback and lots of feedback for process improvement. So this year, I'm happy to say, which I'll report in a couple of weeks, we did improve on some things and some things we didn't improve on, right? Because we still are not at the 30 days yet of processing invoices where our contractors are really looking for that. So, but we had a lot of good feedback about, you know, I'm talking to people, they can help me. We're getting answers the first time I'm reaching out. So there are a lot of improvements. So we'll always have a customer service survey, and we will do that annually. And then we do have our KPM number 3. It's the best practice for boards and commissions. And I know this morning the governance subcommittee discussed this in detail. I know Commissioner Harris and Commissioner Lipscomb were there with Vice Chair Manneberg, and you guys had a great conversation. I listened to it. So lots of feedback and thoughts and conversations around that. So we'll have more conversation around that. I briefly touched on our KPM number 4, which is the trial level continuing learning education. You know, we think that one needs to go away, right? We could, like, what are we really measuring with that, right? So the bar.
I can give you the context. I mean, why that was put in place at the time was it was a new contract requirement that you had to have a certain number of hours specific to the kind of either juvenile or criminal law that you were practicing, because that wasn't what was happening. So they made that a KPM in order to be able to really make sure that people were doing it and that the agency was monitoring it. But that I don't think that's the case anymore, because it's now a contract term, and it's been a contract term for so long that people are used to it.
Right. But then, right. And again, there's that conflict, right? Because
Right.
the contract says 2 years, our KPM is 1 year. So a lot of people are like, well, my answer is no, because I still technically have another year for my 12.
I think that was a mistake.
Yeah,
but
I think it was too.
Yep.
But, you know, so it does cause a little controversy. And again, if we're going to put those contract terms in, we need to make sure that we're following through on the compliance piece of that. And then our KPM number 5 on the PCR, which is our parent-child representation program. Again, what we're measuring, and I am definitely not a program expert in this particular program, but from what has been shared with me from our resource council, who, you know, this is their expertise, we're not measuring the right measure here. So over the last several years, the measure has been pretty low. It's been either 4% or 8%. We have improved a little bit from this last year, but we are definitely not where we need to be. So again, we need to either keep this one and look at how we're measuring things, which we can talk about that. And then we have some new KPM thoughts. We have a new trial division, right? We have 3 offices, one in Salem, one in Portland, and one in Medford. We really need to have a key performance measure around our Oregon trial division. CAP, which is our compliance, audit, and performance area, which is our contract area. It is our policy team. It's the data team. What are we doing? We don't have any KPMs around that, and CAP is relatively new in the last about 4 years. What about agency operations? We don't have anything around internal agency operations. What about our accounts payable or PAE processing time, right? We don't have a KPM. Are we, striving to pay, invoices in 30 days? Yes, that's been a commission policy to do that, but, should we have some measures around that? And then, of course, looking at what the commission would like to do. So we have our phased work plan listed here as well. So we're a little bit behind because we're still like looking at drafting initial KPMs, starting feedback here with the commission. We've established an internal work group of managers to talk about, specifics around key performance measures. But really, this is just my first attempt to come before you to say, we need to start the conversation, hear your thoughts around key performance measures, and then, take it back to the internal work group and continue to work through this pretty rapidly so we can meet our timeline to make sure that we can present in the short session of what our proposed new key performance measures are.
So I think my question is, what data do we want to gather to tell the story that we want to tell to the legislature? Because the KPMs are for the legislature and the public. So what, I don't think, the 30-day processing and all that is really important, of course. And maybe that should be one of our KPMs because it is so important. But is it, I just pulled that out of thin air. Is that, one of the top 5 things that we want to tell a story about? And maybe the answer is yes, we do. But I think this is a huge opportunity for us to change the way that the public and the legislature looks at us, because we have to present on these KPMs annually, and that's the story that we get to tell. So do we want to tell a story about how many days it takes to file an appellate brief? Probably, because we should probably have a KPM for each area that we're working in. Do we need to have a KPM about how many hours of CLE people are getting? No, people don't care about that. We can monitor that. CAP can monitor that. We don't need a KPM for that. So I think that's the, my just sort of overall sense is, what's the story we want to tell? And maybe that's the KPMs that we come up with. What are other people's thoughts, if any? Or questions? Commissioner Knab, I keep wanting to call you that because I know an AAG that has a KN and her. Anyway, sorry.
Yeah, no worries, no worries. No, I agree with your assessment really strongly. I think that the KPMs that are there really don't have any sort of strategic insight. What's the narrative that we're trying to tell about public defense? That it represents a lot of people, that we're doing it efficiently and also providing high quality representation. So, I think that there is no, even if you go among the different departments, there's really like all of those are pretty inside baseball, and it's not like they're going to tell you any of the big picture data that's going to be meaningful to legislatures when they're thinking about how they fund this agency. So absolutely, and I do think that specifically KPMs that show the volume that this agency deals with are significantly informative to the legislature.
Rob?
I think it's really important at this time to develop KPMs specific to PCRP and non-PCRP. This is a story we can tell the legislator. If we can show the performance measures that maybe in the end it saves money, we have quicker reunifications, we have better outcomes for kids leaving foster care, whatever it happens to be, and also it's probably a fair thing for the providers that are getting these extra resources or that are not getting the extra resources to not hold them to the same keep KPMs because they don't have the funding to achieve those KPMs. We have a 12-year quote unquote pilot project now that we're not doing this for. I mean, we're spending millions of dollars more, frankly, in aggregate for these cases on the assumption that we all thought at the time we did this that it was definitely going to be good for the kids and good for the families and good for the society and good for our communities. Let's prove it then, and let's get the extra funding to roll PCRP out statewide. That's my hope.
Yeah, that's a really good point. Other thoughts? Does that give you, Kim, kind of enough information about what we're thinking? Okay.
Yeah,
Um,
it does.
okay. Okay. Anybody else have any other comments or thoughts or questions or things that's important for us to talk about before we wrap it up for the night?
And if any thoughts come up between now and, the next commission or whatever, don't hesitate to
Okay.
let chair know or send something tomorrow. I mean, you can send something to me as well. And, I'll see you in a couple weeks at the commission meeting. So if something, does come up, I'm happy to add that to our list and bring it back to the internal work group. So more to come, definitely.
Great. Thank you. We really appreciate it.
Thank you.
Anything else for the good of the order from anyone who's talked or hasn't talked so far? Ken, you want to say anything?
I just thank everybody, thank the staff for the information provided, and it was a great discussion tonight. I think we're making a lot of progress in some of these kind of sticky issues. So I appreciate all of that from everyone.
Great. Okay. Well, thank you, everyone. With that, we'll wrap it up for the evening, and I'll see everyone in a couple weeks. Thank you.